side. I smashed up the gray one, bought me a red. Every time we hit the parking lot, we turn head. Some hoes wanna choose, but them bitches too scary. Your bitch chose me, you ain't a pimp, you a fairy.
A pimp, not a simp. A pimp, not a simp. A pimp, not a simp. We eat so many shrimp. I got iodine poisoning.
Baby, you been rolling solo, time to get down with the team. The grass is greener on that other side. If you know what I mean, I show you shit you never seen. The 7 wonders of the world. And I can make you the 8th if you wanna be my girl. I say my girl, I don't mean my woman, that ain't my style. Need a real street stalker, walk a green mile. You piling up the paper on the dining room table, cause you able to realize I'm the truth and not a fable. Baby, rock your Russian sable, keep that chiller on the rack.
Hello.
What I look like with some $1,000 shit up.
Hello, testing.
I'm $1 million man that need $1 billion bitch. Put my pimpin' in your life. Watch your daddy get rich. Easy as ABC. Simple as 1, 2, 3. Get down with UGK. Pimp CBU with B. Cause what's a hoe with no pimp? And what's a pimp with no hoe? Don't be a lame. You know the game and how it goes. We try to get chose.
A pimp, not a simp. A pimp, not a simp.
Hello, everybody. It's Artie of Artie's Corporate Fiction, coming to you live on my channel. We're bound to be on a bound to have a very interesting day. I'm gonna ask all of you guys who are in the Zoom call to unmute themselves, so that you could say hi. I just had to mute y'all for the introduction. You could just hit the unmute button next to you in the participant area. So, thank you very much. We have an interesting show for you tonight, if I can actually get this to work. Unfortunately, I didn't realize that Zoom requires a payment in order to live stream beyond 40 minutes, which is not good. So, what we're going to have to do is, it may be apparent that I have to move this to a Google Meet in order for us to get this show on the road. So I apologize for that. I didn't realize that, and it's something I'm going to have to fix later off. I thought they had taken this off, but apparently they put this limitation back on. So I apologize. So what we're going to have to end up doing is, I've set up a meeting already, and I'm going to put a copy of the link into the description, or excuse me, into the chat that you guys can see here. And what I'll do is post it on here, and you guys can join in the meeting from there. And as soon as I get y'all's introduction in there, we can get this show on the road. So again, I apologize for that, but I've already sent out the link into the chat log that's within Zoom. So if you guys click on that, you should be able to join into the meeting, and we can actually get it started. Juan, can you hear me?
Can you hear me?
I can.
Okay.
All right. I'm gonna
You
remove you from
Paymon is here
the
also.
Zoom. There you go.
Paymon is also here, Artie.
Yeah, Paymon. Go to the chat into Zoom, and then you'll be able to click the link, and we're gonna move this to Google Meet. It should be just fine.
I'm in the chat right now, so click on that link you
is
gave me in the
present
chat.
now
Do
the
that.
screen share.
I just did that.
Yes. Juan.
Okay.
Thank you.
Okay. Allow meeting. Yes. Okay. Allow. Something's wrong with your camera or microphone. Steve, can you help me with that?
Oh, you need to get once you click on the link, you need to exit out of Zoom so that the Google Meet can use your audio and video.
Okay. Steve, I gotta get out of Zoom. How would I do it? Just close it up altogether?
Yes.
Test the screen share.
I'll
then.
close it all together. Here we go. I'm going to close up Zoom completely. Okay. That's not Zoom. That's the chat, I guess.
Click it again.
This, right? Leave me.
There we go. There we go. All right.
Okay. So where's our audience? It looks like we lost. We only missed Mandy 777 with us. The lucky 777 lady so far.
We should have all of us are here. Myself, Juan, and yourself. I see Mandy there. And so for now, we're going to get this show on the road as we're already going late. Okay, so now that we got everybody, we can get this started. The discussion for tonight is the answer of this very question that has been agreed upon by the parties, which is, does the requirement to file and pay federal income tax apply to all individuals residing in the 50 states? Or only to those who work for the federal government and or reside in the District of Columbia. Since Paymon was the one who offered the debate and is offering the unorthodox or contrary view, he'll be going first. The debate format will be that each party will get 1 minute for introductions, and then Paymon will go first with 15 minutes to present his side. Juan Galt will have 15 minutes to present his opposition, and then there's going to be about 20 minutes of back and forth between the parties, and then from there we'll have about 5 minutes for closing, and that's when we're going to wrap it up. So I also have a timer up at the top left corner that I'll be changing as we go along. And we are going to get started with Paymon. You have 1 minute to introduce yourself, talk about your channel, and basically introduce yourself to the audience. Starting now.
Folks, my name is Paymon Motahede. Everybody calls me by my first name, Paymon. I'm the president and founder of Freedom Law School, which I created in 1996. I'm an immigrant from Iran of Jewish descent, came to America in 1977 at the age of 14. I've not filed and paid $1 of income tax for 29 years. IRS knows me. They've challenged me. They put 13 years of tax liens on me, over $600,000, which I zeroed out. IRS has checked me very thoroughly as an abusive tax law promoter. After 13 years, they closed it all. And with that, I'm on time still, Artie?
Yep.
Very good. So I want to tell you all, I love you all for thanking you. I want to thank you for taking the time to educate yourself, to seek the truth. But if you seek the truth, folks, you shall set yourself free. It's not me, but it's all in the definitions, folks. Depends how you define things. Okay. I'll tell people.
All right.
That's it. We're done. Yes, go on. Go ahead.
All right. Juan Galt, 1 minute.
Well, I'm a semi-retired attorney, but I still do some hired gun work. My specialties are constitutional law and medical malpractice. I have litigated at all levels in the U.S. court system and have worked on precedent-setting First and Second Amendment cases. However, before becoming an attorney, I was a member of the Posse Comitatus and then an income tax pseudo-lawyer like Paymon is today. So I'm uniquely qualified to debunk pseudo-lawyers. What Paymon will present are his personal interpretations of certain statutory definitions, as you will see. What you will not see is any evidence that specifically addresses or supports his interpretations. Instead, Paymon will weave a narrative out of disjointed, irrelevant misconceptions. In other words, Paymon will present the logical fallacy of incomplete evidence, also known as cherry picking. To the contrary, I will present court rulings that specifically address Paymon's interpretations. Now, if Paymon's fundamental interpretations of how the United States and state are defined are incorrect, his arguments fail.
All right, thank you. So now, again, as we previously agreed to, Paymon, you will have 15 minutes to present your arguments. And let me go get the timer set up correctly. And
before I gotta have a request though.
Sure.
And that is that Juan refrain from ad hominem and insinuations like call me labels like pseudo lawyer, labeling my arguments as frivolous. Please refrain from any of these insinuations. Let's keep it strictly legal. Doesn't matter if you're an attorney. I'm not a non-bar member. Let's just discuss the logic without no insinuations whatsoever, please.
I will. All right, I will agree to that. That we'll keep it. Keep our addresses to our proper names, and so on. And so I'll be sure to catch on with that and catch it when I see it. All right. You have 15 minutes. I will give you a 2-minute warning starting now.
Before I go on, how about my screen? Can I share my screen? You guys
Yes.
will get to see that?
Yes, you can You can share your screen.
So what I'm going to start is by sharing my screen. Make sure I do that correctly. Is this turned on camera? No.
It's
How to share my
present
screen?
now. Present now.
That's audio. I turn off camera. Present now. Okay, let's see. Present now your entire screen. Let's see. It's gonna be this screen. No, I want the this screen. I have to pick one. Okay, share. Let's see. Is that my screen that you guys see?
Yep, we see
Okay,
it.
you see that? Okay. Now when I'm gonna switch, you guys don't see me at all, I guess, for right now. So that's okay. It looks a little bit gray to me. You see it okay?
Yep, I see it.
Okay, all right. Well, folks, you don't have to worry about any of my interpretation because I will not give you my interpretation. I'm going to let you read the law for yourself. You will see only the IRS's own website. You will see United States Treasury regulations as published on the government's own website, or the laws as published by the United States House of Representatives, or U.S. Supreme Court cases, statutes of Congress. That's it. So I don't want you to take my word, the government's word, anybody else, but the direct legal sources from government's own official legal websites. No cherry picking. You read it, the law from government's own official citations, and you'll see it all for yourself. Before I go on, let's go from the IRS. What does the IRS say about this? This is IRS Internal Revenue Manual. Okay, this is what the IRS goes by. Okay, and if you go to the next page, you see under this part 4.10.7.2.9.8 revised January 2006. Importance of court decisions. Let's read together what the IRS says because I agree with what the IRS says here. Decisions made at various levels of the court system are considered to be interpretation of tax laws and may be used by either examiners or taxpayers to support a position. Certain court cases lend more weight to a position than others. A case decided by the U.S. Supreme Court becomes the law of the land and takes a precedence over decisions of lower courts. I'm going to go over the U.S. Supreme Court. You will see Juan will give you lower court decisions which disagree with the U.S. Supreme Court decisions. So look for that in Juan's presentation. He will not give you Supreme Court cases. He'll give you lower court decisions. The Internal Revenue Service must follow Supreme Court decisions. I agree. But Juan will give you lower court decisions that IRS rejects. I'm just like the IRS. Okay. For examiners, Supreme Court decisions have the same weight as the code. The code, of course, is the law. Okay. And the IRS says decisions made by lower courts, such as tax court, district court, or claims court, are binding on the service only for the particular taxpayer and years litigated. Okay. Adverse decisions of lower courts do not require the service, the IRS, to alter its position for other taxpayers. I agree, IRS. Adverse Court of Appeal, District Court decisions do not mean anything. We have to follow we must follow what the U.S. Supreme Court decision says and the code. Thank you very much. Let's go now to this 1040 tax form. It uses the term U.S. individual income tax return. It's all how you define a term U.S. That's the trick. What the deception is there? What does U.S. mean? Well, we're going to go to the Title 26 Internal Revenue Code from uscode.house.gov, government's official legal website, okay? And there you shall see Title 26. From Title 26 Internal Revenue Code, we're going to go down to Chapter 79, Definitions. Here on the definition, it says when used in this title, okay? Okay? And they define all concepts like person, partnership, and partner. Let's go down to A9 and 10 because they define the term United States and state. The term United States, when used in a geographical sense, which is what we all want to know, includes only the states and the District of Columbia. Okay. Well, how about the term state? Well, the term state shall be construed to include the District of Columbia, where such construction is necessary to carry out the provisions of the style. That's right. So you have District of Columbia plus District of Columbia still adds up to only the District of Columbia. So that means in this title, when used in Revenue Code, United States, whatever you read, it means only Washington, D.C. So when you see U.S. intended for a tax form, I'll prove to you further that means Washington, D.C. Let's continue on now to another code. At 7701-826, we go down further. Look at this. They define term trade or business. 7701-826. The term trade or business is not trade or business. It includes the performance of functions of a public office. That's right. Surprise, surprise. It's how you define things that's critical, right? Let's go on. Okay, here is the Supreme Court in the case of Stenberg versus Carhart. This is a year 2000 U.S. Supreme Court. What does the court say in there? Well, when a statute includes an explicit definition, we must follow that definition, even if it varies from that term's ordinary meaning. That's right. The ordinary meaning of the term United States, we think it's the 50 states. Everybody knows that, but doesn't matter. Even if it varies from that term's ordinary meaning of United States, usually we all think of the 50 states. We have to reject that, and we must follow that definition that the statute includes that explicit definition. I'm doing as the IRS says, following the U.S. Supreme Court. Okay. In fact, there's another court case called Gould versus Gould, another Supreme Court unanimous tax case in 1917. And it tells us here we go, that in the interpretation or understanding of statutes, laws, levying, imposing taxes. So in understanding laws and impose taxes, it is the established rule not to extend their provisions. What provision? Provision of tax laws by implication. There is no taxing by implication. Beyond the clear import of the language used, or to enlarge their operation. Enlarge operation of tax laws so as to embrace or include matters not specifically pointed out. If something is not specifically pointed out, the U.S. Supreme Court 9-0 tells us in the tax case it's not there. End of story. But one more. In case of doubt, Supreme Court tells us the tax laws, are construed most strongly against the government power to tax, and in favor of the citizen not being taxed. Doesn't say strongly, folks, in case of doubt. Remember this, folks. In case of doubt, it doesn't go to Juan. It goes to me. They are strongly construed, most strongly. You can't get any stronger than that. Against the government's power to tax. This is the end of the story right here, but I'll give you a few more examples anyhow to prove this case. This is, again, the Internal Revenue Code, Title 26. We have a subchapter 8 tax on petroleum. It has its own specific taxes. Okay, Section 4612A, definitions and special rules for the purposes of this subchapter. What subchapter? Subchapter A, tax on petroleum. Wow, look at this subchapter has its own very specific definitions of not just crude oil, but also United States, right? Look at what the term United States here mean. The term means, wow, the 50 states. They actually list the 50 states. They didn't forget about it here, folks. The government did not forget about it in Section 7701 when, they didn't include the 50 states. Yeah, they didn't forget about it. It was not meant to be here in the Inter-Revenue Code definitions. But in this subchapter means the 50 states and more. The District of Columbia and more. The Commonwealth of Puerto Rico, any possession of the United States, the Commonwealth of Northern Mariana Islands, and the Trust Territory of Pacific Islands, and it includes also continental shelf areas, and it also includes foreign trade zones. Very specific. What one will tell you is to shed can all these definitions. That doesn't matter. 50 states is always included anyhow, and it's not. I'll give you more examples. This is Title 8, Nationality and Immigration, okay? This is A38. When it comes to immigration purposes, nationalization purposes, Section 1101, okay, of Title 20, Title 8. It says the term, look at this, the term United States, except otherwise specifically herein provided, when used in a geographical sense, means, the continental United States. Oh, they actually include that. The continental United States, Alaska, Hawaii, another way of saying the 50 states, and Puerto Rico, Guam, regional islands of the United States, and the Commonwealth of Northern Mariana Islands. See, all these specific meanings have meaning. Guam will tell you, shit, cut all the definitions, doesn't matter. Here's another one, Title 6, Section 1601. The term state, look at this definition, means any state of the United States. Oh, here we go. That's another way of saying the 50 states, any state of the 50 United States. See, they tell you all these. They can include the 50 states if they want to. These definitions have meanings. And the District of Columbia, Commonwealth of Puerto Rico, Virgin Islands, Guam, American Samoa, the Commonwealth of Northern Mariana Islands, and any possession of the United States. See, they have these very specific definitions all over. Here's another section, 3121. This is employment taxes from Title 26. Guess what? Section 3121 has its own definitions. This is the FICA, Federal Insurance Contribution Act, comes out of your paycheck. The Social Security tax is so-called, right? Here you will see that it goes down under 3121. 3121E has other definition for the purpose of this chapter. What chapter? This chapter is on Federal Insurance Contribution Act only. For this part of the Internal Code, there's a specific definition that one will tell you, shit can it, because 50 states is all automatically included, he says. Look at this, okay? The term state includes the District of Columbia, the Commonwealth of Puerto Rico, the Virgin Islands, Guam, and American Samoa. How about United States? When used in a geographical sense, it includes the Commonwealth of Puerto Rico, the Virgin Islands, Guam, and American Samoa. Well, interestingly, look at this. Here, state includes the District of Columbia, but United States does not.
2 minutes.
Wow.
2-minute warning.
Yeah, thank you. See, isn't that interesting, folks? Look at this. So one will tell you, shit can all this stuff, these definitions, and go with a lower court. Say, ignore the law you're seeing, ignore your Supreme Court, ignore all these different definitions. Where one will tell you only go with the lower courts that the IRS itself tells you we're not going to go that. IRS says that the Internal Revenue Service must follow Supreme Court decisions, and I agree. That's all we should go. I'm going to give you one more definition. Title 28, Section 3002, Judiciary and Judicial Procedure. Here you'll see in this section, where's that subsection on that guy? They have different definitions. No, I didn't get those, did those. Yeah. Anyhow, that's enough. I got enough. Remember this, folks. Any doubt you have, the courts have said interpretation of tax laws, right, must go strongly, most certainly against the government and in favor of citizens. Now, so Juan must prove by showing statutes, by using U.S. Supreme Court cases to show I'm wrong about all this. Juan, please go right ahead. But let me tell you this, folks, don't be afraid. Don't be afraid, folks. I come from Iran. We had no freedoms there. Yeah, freedom of speech. The lower courts are corrupt. Department of Injustice, FBI, CIA, they're corrupt. Okay? They try to frame Donald Trump 3 years of this Russia conspiracy hoax. The federal government is corrupt, and you know it. So don't go with these lower court corrupt decisions that just ignore the law and Supreme Court because they're part of the crooked deep state to keep you a slave. Be free like me by having the courage to look at the law and speak truth to power. It's yours.
Okay. Thank you very much. And now we are going straight to Juan. When you're ready, I will start the timer as soon as you begin.
Okay. As I said before, if Paymon's fundamental interpretations of how the United States and state are defined are incorrect, his arguments fail. And I'm going to start with a case of U.S. v. Ward. Can I screen share now, please? Okay, United States versus Ward, 1988. Ward made 3 arguments, and 2 of them are the same arguments that Paymon makes. Cases I'm going to address here, unlike what Paymon just showed, no Supreme Court cases that says anything about his interpretations. I'm going to give you cases that talk to his interpretations because Ward had them. He had them by an attorney called Beecraft that Paymon uses. So let's see what happens here. First, he suggests that the United States has jurisdiction only over Washington, D.C. That's what Paymon says. And he interprets the individual within the Internal Revenue to apply only to those individuals located within this jurisdiction of the United States. That's what Paymon says. Court says Ward reaches this twisted conclusion by misinterpreting a portion of the income tax code. The 1913 Act defined the word state and United States to include United States territories and District of Columbia. Ward asked this court to interpret the word include as a term of limitation rather than definition, and so does Paymon. What did the court say? We find each of appellant's contentions to be utterly without merit. Well, now Paymon may say, well, that's a lower appeals court case, a lower court. SCOTUS is the highest court in authority. He's right. And Ward must have thought the same thing. So he appealed to SCOTUS. And how did SCOTUS react? After reviewing his appeal and arguments, they denied to hear the case, which means the appeals court decision in Ward stands as controlling case law. It is now precedent, and as such has been cited almost 300 times. Therefore, there is no U.S. court that will accept Paymon's interpretations until Ward and all the case law established since is overturned. Let's continue. Let's go to 1989 Beecraft versus U.S. Nelson, where this attorney was sanctioned for bringing forth these frivolous claims. And the frivolous claims were thinking that the limitations of federal jurisdiction were to the United States territory and the District of Columbia. And thus the inapplicability of the federal tax, like Paymon talks about, does not apply to the residents of one of the states. And the court said this has no semblance of merit, and Beecraft should have known it because he had already lost the case. So they sanctioned him $2,500. The next case, we're up to 2011, U.S. v. Morgan. And they have about 4, they raise 6 arguments. They have 4 of them that Paymon uses, the meaning of includes and including, trade or business, and United States and state. And of course, the court goes and quotes the U.S. v. Morris, which says they're incorrect and it's frivolous. All the arguments are frivolous, as the courts say, not me. And of course, here they quote U.S. v. Ward, which is the controlling case that found utterly without merit the claim that the income tax limits the definition of United States to the District of Columbia and the aforementioned territories. In 2008, U.S. v. Morris, these people didn't get in deep as Paymon does, but they went with the employment in the private sector, which Paymon talks about, the trade or business. And of course, the court said it was utterly without merit. And this court has long held that this type of argument is frivolous. Not my words, the court's words. Now, also, I found this one real funny. It's even bled over into the bankruptcy court. Here's a bankruptcy court where the debtor believed the United States, when used only in the geographic sense, refers only to the District of Columbia and territories. And thus, he thought he could exclude his wages from Northwest Airlines. Well, the court, quoting Ward, said, no, that's frivolous and without merit. And then here's this Callahan. Now, Paymon makes a big deal about, well, it doesn't say specifically mention the 50 states. So if it doesn't do that, well, it doesn't mean that. Well, what did the court say about that? Well, the tax court said that they rejected that argument and thoroughly discredited it as frivolous. And the circuit court, appeals court, agreed. They had to, because they're governed by U.S. v. Ward. In U.S. v. Cooper, the court sanctioned the defendant like one of Paymon's customers if they filed these frivolous claims that Paymon promotes. He was sanctioned, I don't know, I think it was $2,500. So all of these cases go right in line with the definition in the Internal Revenue Code, which defines includes and including, when used in a definition, shall not be deemed to exclude other things. In other words, they are not limitations as Paymon interprets them. Now here, I found this case here. They don't make any of the arguments that Paymon does, but it's that attorney, this Beecraft attorney that Paymon uses. Actually, Paymon credits him with this legal knowledge and research that Paymon uses. But this guy, he tried to say that the 16th Amendment was never properly ratified. And that court said that is ridiculous. And Beecraft appealed it to the Supreme Court. The Supreme Court said the same thing, looked at it and said, we refuse to hear this. So this case here is also precedent that has set. So evidently, Beecraft is one hell of an attorney. He sets a lot of precedent, but not for his client, for the government. And there were plenty other cases. Like I said, Ward has been cited 279 times that I could find. There's probably more. Why? Because it is the controlling case law on the arguments that Paymon puts forth. It's as righteous as a Supreme Court decision, because there's no place you can appeal, because the Supreme Court has already rejected those arguments. And I'm done.
All right. That is there. Thank you very much, with plenty of time to spare. So right now, we're to go through our first round of super chats, and then we're going to go through the open discussion. So, Mandy, if you would be so kind. Mandy? Hello? We can't hear you if you're talking.
She probably thought I was going to be a little bit more long-winded.
Maybe she has no questions at this time. Looks like that's the only person we have listening at this time, right?
Well, me see if I can get these out here.
On my screen, I see only 4 of us. How many people are actually watching or listening to this program right now?
In my chat, we have about 250 people watching on my live stream. Okay, so Mandy's having some technical difficulties, so I'll go ahead and go through the super chats myself. All right, it's all good. Okay, P Barnes says a $7.17 super chat. Juan sounds like a no-nonsense crime-fighting attorney in a TV show that I would definitely binge watch. Akira 808 State, $4.99 super chat. This is gonna be good. Joanne Sally sent a $2 super chat. Hi Artie, hello yourself. Taco and Yoshi Gaming sent a $2 super chat. I don't know what's more painful, this or Elden Ring. I feel you on that one, buddy. Friggin' Pope, $5. It's all moot though. If these definition loopholes actually existed, Congress would pass a law closing them within 24 hours. Thank you very much, Pope. 90s Nostalgia Nerd, $5. By his logic, a cup of noodles that says includes beef flavor packet could be a container that just has the flavor packet. Thank you very much, Nostalgia Nerd. And Auditing the USA, another troll account, $2. I'm an audit god and chicks love to get with me. Okay, that's cute. Anyway, I'm not even gonna go entertain that wildness. But now we are going to go with the general discussion. It's going to be about 20 minutes. All I ask is, again, keep the labels to yourselves, address each other properly, and do your best not to talk over each other or gish gallop the conversation. So with that said, hey, I can hear you now, Mandy. With that said,
sorry, don't know what happened. Apologize.
it's okay. With that said, we're gonna start the 20 minutes and now, and I will let Paymon provide the initiating response. Go. Paymon, you're muted.
Here we go. I'm muting myself.
There you go.
Let me see.
Now
My
we can hear
camera
you.
doesn't seem to be working right now, though. Can you guys help me with the camera? My camera, turn off. And the camera doesn't seem to be working for some reason. Guys, can you help me get my camera going for right now? Anyhow, all right. Well, my help helps me with get the camera to see me because I don't hide myself like Juan does. You can see my face, actually. You're welcome to see my face. I'm public about it. I don't hide. First of all, I want to make some minor corrections to Juan, what he said. Okay. He somehow attached me to Larry Craft. And he said that Larry B. Craft is the one that taught me about these things. That's absolutely not true. That is a baseless claim of Juan. I learned this stuff on my own, not from Larry B. Craft. So I'm accused of cherry picking things and say stuff not true. You can call Larry B. Craft yourself and ask him, did you teach Paymon about these arguments? He'll tell you no. Larry B. Craft's number is 256-533-2535. Verify everything for yourself. Second, notice that Juan did not even attempt to refute any of the laws you found as published on the United States House of Representatives Council's website. They published the law directly for us to go to the law from directly the authority, the lawmaker. The House of Representatives published the law for us to follow. He never even attempted to dispute any of my websites. I didn't cherry pick anything, folks, as he tried to mislabel me.
Well, hold on. Before let's have Juan respond. If you could, you
Sure,
kind of said a
about
lot
Larry
there.
Craft, yes, it responded to Larry B. Craft issue. I guess that's why I'm sorry. One at a time. You're right about the segue Larry B. Craft. Go ahead, Juan.
Well, the only reason why I said that is because we've discussed Beecraft, you and I, privately, and you have told me that you know him. Also, I got that from your videos. In one of your videos, you thank him and you tell people, I want to thank Larry Beecraft for providing me with this legal research. That's what you say. So I'm just repeating what you've said, Paymon.
Well, this is when, unfortunately, Juan, you cherry picked what I said there. What I did actually say in that video traces the history of the income tax going to 1913. Okay. And in that video, which I'm going to bring it from you right now, Bobby, you can see it momentarily. In that video, I show statutes from statutes at large. I want to thank Larry Beecraft. It was about providing me those guys. Could you put my screen back on for me, please? First, providing me all the statutes at large of Congress. Guys, can you give me a computer back screen for me, please? For providing me all the statutes, tons and tons and tons of them, within which I found those statutes at large, because they're typically hard to find on the left one. Yeah. So what you're going to see right in a moment, I'll show you. It should be coming up. It's not coming up yet, this screen. Up there, can you guys see my screen? Yeah. Is that those research I got from him? Not that Larry told me that definition of the United States in Internal Code means Washington, D.C. Okay. Okay. So
Artie needs to give you permission.
Artie, can you give me permission to share my screen, please? I need your permission to share my screen.
You should have permission to share it.
It says can't share a screen. You must get grant permission in order to screen share, it tells me. I'm going to dismiss that and let you do that. So now we got that. So you find out it's not me that cherry picks and say things out of context incompletely. He saw in my video that I got that huge library of laws with which I found a few key pages, and he didn't take the time to watch my whole video. And I'm going to show you here it is right now coming up. This is it, folks. Yep. You see right here, this presentation, this release, these things that you see right here. This is what Larry Beecraft gave me within a bunch of various, here it goes. This is 1913 law with a bunch of other stuff. I just found stuff in the library that he provided. So having said that, did I say something else that Artie needs to respond? Go ahead. I mean, Juan, you want to respond? Go ahead and respond to what I said. Otherwise, Juan, please.
Yeah, because right there with the screen you got there, and the screen that you used with 1913 one also, you talk about the definitions and the includes, and so if all I heard you say was, I got this, I want to thank him for this legal research. So, I just put it as a whole, the legal research and what you were saying while you were showing this stuff, really is the arguments you make today, is all I was saying. So if I cherry picked, I certainly apologize. I was just repeating what I heard you say. And the rest, and the Beecraft is really a irrelevant issue to the whole deal. But anyway, you got to protect what you feel.
Yeah, I kind of feel like talking about whether or not you were influenced by Beecraft is kind of setting us away from the crux of the actual argument here, which kind of involves interpretation, right? So, can you address Paymon? Can you address some of the court cases that were that Juan Galt cited? Okay.
Well, let me ask something. I haven't got to say much here.
Sure. Go ahead.
I want Paymon to produce one court case. I don't care whether it's a lower court case or a Supreme Court case, but I challenge him to produce one case that says his interpretations, or the way he interprets it, is the law. And he has yet to ever produce any one single case that lays out it like it did in Ward and the cases I cited. Does he have one or not?
Okay, let me address that issue. First of all, bottom line is this. I'm going to take the same position as the IRS does. As you see on my screen, IRS says importance of court decisions. I 100% agree with the IRS. I don't know about you, Juan, but I think IRS is 100% right on this. I agree with them. Okay, that they say that with the Internal Revenue Service must follow Supreme Court decisions, and I do too. Okay, so NSA decisions by lower courts, right, are binding on the IRS and the American people, all of us, only for the particular taxpayer like Ward and the tax years litigated like Ward had. IRS says the Ward case that you cite applies only to Ward and those particular years of Ward. IRS says that still today, the IRS and all of us must follow Supreme Court decisions. So I go with that. And the Supreme Court clearly tells, I give you just two cases. That doesn't matter if the lower courts ignored, because lower courts can. Let me say something else before I go on. You know, judges are human beings just like you and me. They're not gods.
Objection. Narrative.
Okay. So bottom line is that they are corrupt and crooked too, the lower level courts. Okay. So just because some crooked court like Ward deliberately ignored things doesn't mean that they're right. In fact, give me the Ward citation. I'm bringing up right now in front of you the Ward decision. Put that on the screen. I'm going to put the Ward case that you have on there on the screen, because if I can get the Ward on my screen, I'll do that. In Ward case, notice that these crooked courts did not discuss these codes at all.
That's not the Ward case I quoted.
The first one is Ward, you mentioned. Everything is based on Ward. They all cited on Ward. They went based upon Ward. So several of them were relied upon Ward, as you said. And the Ward case, the crooked 11th Circuit Criminal Court of Appeal, deliberately did not discuss anything. They mentioned nothing about Title 26, Section 7701, A9 and 10. Oh, he claims 7701, A9 and 10 define United States as this quote. Oh, hi, at Court of Appeal, why did you not quote Section 7701, A9 that says United States, and state basically mean Washington, D.C.? Why did you not quote it and then refute it? Oh, I know why.
Okay. Paymon, again, you're kind of
okay, because
you're kind of blustering here. Give Juan a chance to respond. All right.
Well, let me finish this. So all I said, you got to go by what Supreme Court says. The Court of Appeal Ward, according to IRS, means nothing.
Okay, can I talk yet?
Yes.
Okay.
Yeah.
SCOTUS, by denying a hearing after reviewing Ward, said the lower court was correct. The Supreme Court said that ruling is going to stand. When the Supreme Court refuses to hear a case, that means that the lower court decision stands as precedent, stands as case law, because the Supreme Court has spoken. And what they have said is, we don't need to hear this. The lower court was right. And the tax court and the IRS quote Ward in probably at least 100 cases that I've looked at. So the Supreme Court, so the tax court and the district courts and are binding on the service, just like it says, because Ward is controlling case law when it comes to these arguments, period, full stop.
Okay, I'll respond back to that.
And by the way, you are quoting and looking at the wrong U.S. v. Ward. You were looking at a case from 2000. The U.S. v. Ward case is from 1988. It was on the screen.
Well, I didn't get a chance to write a citation. That's all. And online, the newer ones came up. That's all it was. Okay, let's.
I gave you all of these court cases 2 weeks ago
No, I didn't get
to
that.
explore.
No, I didn't get.
Yes, you did, because you said the same thing there,
Okay,
Paymon.
okay.
You said these are lower court cases. I go with the Supreme Court case. You said the
Okay,
same
yes,
thing.
I did. Okay, fine. No problem. No problem. I didn't look at it before. It doesn't matter. Let
Well,
me
yeah,
get
it
this
does,
one.
because it blows your argument. It shows you're ill prepared, and it shows you didn't study
No, it
the
means
ruling case law in this discussion.
just because I pulled up the wrong one on my screen, don't read any more than what it is. You just pulled up the wrong one on the screen. Okay, let's not
I gave you
sidetrack.
the I gave
Let's
you
not
the correct
sidetrack.
I
Let me.
gave you the correct site 2 weeks ago.
Can I talk without being interrupted?
You have been. Go ahead.
No, you've been interrupting me. So let me talk without
And
interrupting.
in fairness, Paymon, you have been eating up a lot of the speaking time. But I want to try and give Juan a chance to respond. And I think,
Juan.
and I would like you, and for the future, I would like you to be able to make your point concisely and not. You tend to kind of go on and on and on, and I need you to kind of be more concise in your responses.
Okay, fine. I'll make it very short again. It's very simple, Juan. You know what? I agree with the IRS on their website, as you see on my screen. The IRS very well knows that, just like everybody else out there knows, that the Supreme Court, out of maybe 1,000 cases that are asked to hear, maybe hears 1 out of 1,000, or something like that. 1 out of 1,000, 1 out of 5,000, something like that. Most of the cases people ask the Supreme Court to hear, they don't hear because they simply do not have human power to review all these number of cases. So just because the Supreme Court did not review that case, it does not mean the Supreme Court agrees with that. Yes, for that time being, the lower levels will go with that court case until down the road, at some point, the Supreme Court may correct or may not. But that does not change that U.S. Supreme Court decisions are still the law of the land, as the IRS says. IRS on his website does know what you said. They know that for practical purposes, a lot of times you got to go to Court of Appeal. It's practically the law, and the U.S. Supreme Court is ignored by this criminal federal courts of appeal, district court, tax courts. They know that, but the IRS still
Mr. Paymon, I apologize, I have to interject, but I believe the Ward case was a circuit court decision, not something that was on the district, claims, or tax court level.
Yes, I said it's a court of appeal, circuit. Yes, that's what I said.
So if it's
That
so
is
it's your contention that the circuit court is at the same level as, in terms of the IRS treating it as binding, as the tax court, district court, and claims court. In other words, the IRS has no need to bind themselves by the decision of the Ward decision, which is a circuit court of appeals decision.
Well, that is what IRS says on this page in front of you, the IRM. You see it in front of you? Okay.
Well, I see it says tax court, district court, and claims court, but not the circuit court.
Well,
the circuit court of appeals.
Well, lower court. Lower than what? Lower than the U.S. Supreme Court. And I think you agree that federal courts of appeal are lower than the U.S. Supreme Court. So just because they're not specifically mentioned in the lower circuit courts of appeal, obviously they're clearly implicitly included as being lower than the U.S. Supreme Court. So IRS says, hey, they're not binding. Ward is not binding on the IRS, only on Ward and those taxers, what the IRS says. And I agree with the IRS. And the IRS says that only U.S. Supreme Court that they must follow. And I say, so do me and the American people, case closed.
Well, that's just totally wrong. The Ward is precedent. And its precedent is why it's been quoted almost 300 times, probably over 300 times, and quoted by the IRS attorneys, quoted by the tax court administrative law judges. Paymon doesn't want to accept it because it will blow his entire career and income. Because if people knew that what he is selling absolutely has already made it all the way to the Supreme Court, and the Supreme Court said it's BS. the lower court had it right. We're not going to touch it. That's what the Supreme Court does. I've been to the Supreme Court. I've got a good buddy that's a justice there, one of my fellow alumnus. So I kind of know how the Supreme Court operates, and I'm sure Artie does too. Ward is precedent. Bottom line, there is no argument on that.
All right, we got 2 minutes left. So so let me just try to get the ball rolling back to the original point, which is the interpretation of United States versus states as it's written in the Title 26. The argument that's being made here, that decisions made by the lower courts, such as tax court, district courts, claims courts, you say, Mr. Paymon, you say that implicitly also includes a circuit court decision, saying that the IRS is not obligated to them. Could that sort of implicit understanding be applied to your definition of United States as it's written, as it's defined under Title 26? That just because the several states aren't included on the definition of United States, it can be implied that the several states are also included in that definition?
Well, again, if you review everything, I showed you many examples that the term here is, for example, Internal Revenue Code, the FICA law, has its own specific definitions, Federal Insurance Contributions Act. In this case, the term state means DC, Puerto Rico, Virgin Islands, Guam, and American Samoa. Hey,
It says includes.
includes. So at what point? So here, but the United States on the other hand does not include, doesn't mention DC. How come? Wait a minute. So do you read DC United States because it's not there? According to Juan, Congress is stupid. Congress is idiots.
No,
you state by United States. They don't mention it. Obviously, must be in there.
No, you go back to 267701. It says, as used in this title, unless specifically or unless defined in a different chapter or in a different area. I mean, it's covered right there. You've read it. It says it's used in this chapter unless it's changed somewhere else for necessity in a different chapter. That's all that is. You still cannot appropriately and properly construe statutory language. And you still don't understand that when a circuit court, not a district court can be a lower state court or something like that, but a circuit court, a circuit appeals court is the highest court in the land next to the Supreme Court. And when the Supreme Court agrees with the lower court, that's precedent, my friend. And that's binding.
Okay. We have hit the 20-minute mark. I'm going to give both parties 3 minutes to make their closing statements. We're going to start with Paymon, and we're going to start at 3 minutes starting now.
Well, it's very simple. Don't need, bottom line is that, I agree with the IRS. I agree with what everybody knows. The code, the law, the language of law is what matters. And the U.S. Supreme Court has clearly said to us that when a statute includes an explicit definition, we must follow that definition, even married from terms ordinary meaning. And it is axiomatic, self-evident that statutory definition of a term excludes unstated meanings of that term. That's right. It excludes what's not stated in that definition. And the Supreme Court says, in case of any doubt, we must go most strong against the government and in favor of citizen not being taxed. And guess what? Our IRS and me agree with the Supreme Court decisions, because IRS says that U.S. Supreme Court that that a case decided by Supreme Court becomes law of the land and takes precedence over decisions of lower courts, lower than U.S. Supreme Court, which obviously includes the circuit, federal courts of appeal, district court, tax court, and on and on. So I agree with the IRS, so everybody knows what Supreme Court says is the law, and it takes precedence over decision of the federal courts of appeal, like the ward that Juan wants to rely upon. So bottom line is Juan sees that he's wrong. This is from directly from the IRS's website, from Supreme Court decisions, from the statute published by the government. Read it for yourself and decide what is the truth for yourself, folks. I'm done.
Okay.
And there was much rejoicing.
All right. 3 minutes. Juan. Starting
Okay.
now.
Okay. Well, first of all, there is no doubt involved in this case, because what you've seen is Paymon presenting his personal interpretations of certain statutory definitions. What you did not see is any evidence that specifically addresses or supports his interpretations. Instead, he's woven a narrative out of disjointed, irrelevant misconceptions, and the Supreme Court agrees. SCOTUS did speak to Ward. It spoke by denying the hearing. That is the way it works in this country. In other words, Paymon presented the logical fallacy of incomplete evidence, also known as cherry picking. Now, if Paymon's fundamental interpretations of how the United States and states are defined as incorrect, and they are, as we've seen the Supreme Court and lower courts say, his arguments fail. His arguments have failed here tonight. They failed in 1988, 1989, 2008, 2011, and continuing today. Thank you, Artie, for putting this together.
Okay. Thank you very much to both of you. I apologize for the technical hiccups from the initial one. I guess I'm going to have to suck it up and purchase a purchase a plan for one of these video conferencing calls, whether it be StreamYard, Google, or Zoom. But I want to thank you both for coming out. I want to thank you both for I want to thank Paymon for offering to set up this debate. I think it was fairly decent. I kind of wish it got a little bit more time. But we may have to be able to do this another time at least. But I appreciate you both adhering to the format, keeping it as civil as it can be. And I thank you very much, all of you. And thank you, and I will see you guys next time. We're going to Mandy and I are going to close out with reading the remaining super chats. But again, I want to thank you guys for your time and coming on to the show.
Alrighty, if I may, I'd like to give everybody our website so they can go check us out in more detail for themselves, folks. You can go to Freedom Law School's website, livefreenow.org. And the videos, the petition to Congress that lays out all these laws and court cases are there for you to check it out for yourself. Livefreenow.org is the place you want to go to educate yourself to freedom. Thank you for having this forum for us, Artie.
Sure. Juan, you want to plug?
I just say, if you want to know the truth, just rewatch this live stream.
All right.
Or go to my YouTube channel, Juan Galt.
All right. Thank you all. You take care. Have a good one. Okay. I apologize, Mandy. The Google has its own time limit, so it was going to close out for everybody anyway. So I apologize for that. So I'll just go through the remaining super chats. before we close everything out. Like I said, I kind of wish we had more time to go on a little bit longer, but I had to rush it because of the time constraints. We'll have to take care of that. Again, another time I'll have to just expend some money for an unlimited streaming conferencing platform. So, Peter Jerd, $5 super chat. Paymon demanded that Juan not make any ad hominem attacks, but then turns around and attacks Juan for hiding his face. Yeah, I never really got that sort of thing. That's always been like an internet thing. Well, show your face type of thing. It's kind of Yuko Valis Sword, $5. Paymon says all courts are corrupt. That's just why he can't find a single case to back up his claim. So why does he teach that what will fail regardless? That's a very good point. I always find the application of, oh, well, they're all corrupt in the first place to be kind of a cop-out, but it is what it is. Pat's Cats, $1.99. He can't prove his position. I assume referring to Mr. Mutaheda. Thank you very much. And then Doug, thank you very much for the $25 super chat. Much appreciated, Doug. Word salad. Yeah, kind of agree there. Okay, thank you guys again. I hope we can do something like this another time. I know I've been out of the debate scene, and nobody wants to have a discussion with me. I'm open to it, but we'll see what happens later. As far as this week goes, I'm not going to be streaming tomorrow. I'm going to give myself a break. But if I am streaming, it'll be on my gaming channel for more Elden Ring. I probably will not be on this channel for streaming until maybe Thursday, maybe Friday. So take a look at that. But I appreciate you guys coming in. And I hope to see you guys next time. Have a good night. Take care. And adios.
A pimp, not a simp.